So what happens when you're in bankruptcy and you need to sue somebody? Can you? Check out our video for some more information. So you're in a Chapter 13 bankruptcy anywhere from 36 to 60 months because you're doing a repayment plan. But guess what? Life happens, lots of things can go on, and you may end up where you need to sue somebody. And it can be a personal injury lawsuit, it could be a divorce. I'm a lawyer, so of course I know there's lots of different ways that you can sue people for different things, but things will come up. And so one of the common questions that we have from clients is, can I sue somebody while I'm in bankruptcy? And the answer is yes. You can actually continue or pursue a lawsuit while you're in a bankruptcy case, but with a Chapter 13 bankruptcy, there's a couple of steps that need to take place so that you can, if you are going to recover something, you can recover that settlement and you don't have to worry about being barred. So here's what you have to know. Number one, if you are suing somebody before you're in the bankruptcy case, or even it happens after you file for bankruptcy. So anytime before the Chapter 13 or after the 13, if you have an attorney for any reason, you need to let your attorney know. And there is it's called an application for special counsel, and it needs to be filed so that the bankruptcy court can approve this person being your attorney. It's not a big deal. It's just you need to provide usually a copy of the contract you have with that attorney, and then that attorney will sign off on something called a verification, just that they are able to represent you in court, and then in our district at least, we file the application, so there's no real burden placed on your other attorney. We file that application so that this attorney is approved. And then once you reach a settlement, or your attorney reaches a settlement, then there is a motion filed to approve that settlement so the funds can be distributed accordingly. Now, why this is so important is some folks think that they're gonna just sneak one by the bankruptcy court and just not tell their attorney that they're in bankruptcy and that they'll just skip this whole process. Well, what's going to happen is opposing counsel will ask you in a deposition or an interrogatory, have you ever filed bankruptcy, or are you in a current bankruptcy? And of course you're under oath when you're answering these questions, so you're going to have to answer yes. And then the next thing they're going to do is check to see if you've even disclosed that this claim is an asset. And if you don't, then you can be barred from collecting anything. So it's a big deal. And you want to make sure that you're doing everything right and that you're playing above board. So make it easy. Let your attorney know, the other attorney, not your bankruptcy attorney, let them know that you're in a bankruptcy case. Typically the attorneys will just talk to each other, they'll get the documents from each other, and it's a super simple process, but you need to make sure that you disclose it. We see this come up, not with our clients, knock on wood, our clients I think have been great about always disclosing what they need to in regards to lawsuits, because we really hammer this home, but we have seen in court some cases that went really, really badly because people were just hiding their lawsuits and they actually were denied recovering anything. So make sure if you do need to sue someone while you're in bankruptcy, by all means go ahead, sue, but make sure that you let your attorney know, both attorneys know, that number one, you're in bankruptcy, and then let your bankruptcy attorney know that this has come up. And we can always guide clients in regards to what they need to do.